Namaskar and welcome to the discourse on the role of the High Courts in the protecting human rights. Friends, to introduce the subject, there shall be a High Court for each state in India, but the Parliament has the power to establish one common High Court for two or more states. The High Court stands at the head of the judiciary in the state. When one talks about the protection of human rights and the role of the High Courts, one is taken to the Article 226 of the Constitution of India. The Article 226 starts with the marginal note, power of the High Courts to issue certain writs. Notwithstanding anything contained in Article 32, every High Court shall have the power throughout the territories in relation to which it exercises its jurisdiction to issue to any person or authority, including in appropriate cases, any government within those territories, directions, orders or writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, and any of them for the enforcement of any of the rights conferred by Part 3 and for any other purpose. By reading this provision of Article 226, it is clear that Article 226 is wider in scope than Article 32. Under Article 32, the Supreme Court may issue writs for enforcement for fundamental rights only, but under Article 226, the High Court may enforce not only fundamental rights, but also any other legal right. For example, to enforce the right to property under Article 300A of the Constitution, which is not a fundamental right. An important aspect of the Indian Constitution is the jurisdiction it confers on the High Courts to issue writs. Thereby, the High Courts are made the guardians of the people's legal rights. The writ system provides an expeditious and less expensive remedy than any other remedy available through a normal court process. As far as the protection of the human rights is concerned, the powers of the High Courts of enforcement of human rights guaranteed under the Constitution and other legal rights under Article 226 is required to be reviewed by referring to the case laws. Among the human rights, in this discussion, the High Court's role in the protection of Article 21 of the Constitution shall be confined. Article 21 is the right to life and personal liberty. The most important of the fundamental rights may be said to be the right to life. Article 21 reads as, no person shall be deprived of his life and personal liberty except according to the procedure established by law. The High Courts functioning in the states are playing considerable role in the protection of the enforcement of Article 21. In this discussion, two aspects shall be covered. One is the role of the High Courts in the areas of health, hygiene and sanitation, and another area is regarding custodial violence and the reliefs granted by the High Courts. Some decided cases of the High Courts will be reviewed to appreciate the protection of the human rights by the High Courts. Let us discuss custodial violence. Custodial deaths are perhaps one of the most heinous crimes in the civilized society governed by rule of law. The rights inherent in Article 21 and 22 of the Constitution require to be jealously and scrupulously protected. This is well illustrated in the Guwahati High Court case in Kaminibala Talukdar versus State of Assam, reported in 1997 Criminal Law Journal, page number 874. In this case, a boy who is said to be a member of the unlawful organization came to spend a night out with his mother at home. In one forenoon, he was in his courtyard playing carom with some friends. At a time, 4 motorcycles with pillion riders came and stopped at the gate. Later on, they are identified as police in civil dress. They chased the boy who was playing and fired shot upon him, causing his death. His mother filed a writ petition before the Guwahati High Court under Article 226, complaining that the life of her son has been deprived of without due process of law. The answer given by the state was that police attempted to arrest him, and in the process, firing was necessitated, and as a result, he died. The court had to see as to whether firing was really necessitated or not. The court relied upon medical jurisprudence, where it is pointed out that if firing done in point blank range, that is within a distance of 3 feet, then in all the entrance of the bullets, tattooing mark will be exhibited. So in the present case, the post-mortem report has shown that all the bullets which hit the victim have shown tattooing marks. The court came to the conclusion that all the firings are done within a distance of 3 feet, and held that in order to arrest one unarmed boy by 8 police personnel resorting to firing in an act is depriving of the life of the boy, not in accordance with the procedure established by law. The court awarded compensation to the mother of an amount rupees 1.5 lakh and directed the state of Assam to recover this amount from those 8 police personnel. Various other high courts also reacted seriously in the matter of custodial violence. The Bombay High Court found custodial death in Solgabai Power versus State of Maharashtra, 1998 Criminal Law Journal, page number 1505. Due to the excess and maltreatment in the police custody, and awarded compensation of rupees 1.5 lakh against the state in favor of the petitioners, the widowed wife of the victim. In the latter cases, the high courts are seen to award compensation in custodial violence at high amount. In Phulwati versus National Capital Territory of Delhi, 2000, Criminal Law Journal, page number 1613, custodial death was caused due to beating by the police. A compensation of rupees 3 lakhs has been awarded by the Delhi High Court. The aspect of health, hygiene and sanitation is also worth consideration, because it is a very important aspect. Under Article 47 of the Constitution, It lays down the duty of the state to raise level of nutrition and standard of living and public health. Various issues of public health arose in India, and the problem relating to persons tested positive of HIV expresses one aspect. The Bombay High Court has confronted with such a problem in MX of Bombay Indian Inhabitants versus MSZY, reported in AIR 1997, Bombay 406. The petitioner was working as a casual labourer with a corporation through a contractor in the year 1982. In 1986, the petitioner was interviewed for a vacancy against a regular post in the corporation and employed as a casual labourer from 1986 to 1994. In various tests, he had no comments from the doctors of his unhealthy condition relating to his bodies, except the presence of HIV antibodies. The report of ELISA tests showed HIV 1 and 2 positive for antibodies. The certificate shows that the disease is a prolonged one. The patient acquiring the infection can remain asymptomatic for a long time, extending up to 1 to 12 years. In the present case, after having the knowledge of the HIV status of the petitioner, the senior manager of the corporation deleted the name of the petitioners from the select panel of the casual labourers with immediate effect. The petitioner wrote letters to the corporation with the submission that in spite of having HIV status, he is fit to load drums on the truck, and also that he is the only earning member of the family and he is rendered out of job. His family will find it difficult to survive. He also said that he is very poor, having his wife and 2 children dependent on him. The petitioner requested for allowing him to work as casual labourer as before. The petitioner also wrote one letter to the Additional Director of Health for making intervention in the matters. The Additional Director of Health, Maharashtra, wrote a letter to the corporation pointing out that the HIV positive status of the petitioner may take 8 to 10 years to develop symptoms of AIDS. The Additional Director also hinted the corporation that HIV AIDS is not transmitted by casual contacts, by working together. It is transmitted when the blood is transfused to the other or having sexual relations. Barring that 2 cases, the petitioner is not going to pose any risk to the others. The High Court observed HIV infected and AIDS are global problems. The petitioner prayed for direction for reinstatement in his job by giving direction to the corporation. No person can be deprived of his right to livelihood except according to the procedure established by law. The state or corporation cannot take ruthless and inhuman decision that they will not employ a person unless they are satisfied that the person will serve during entire span of service from employment till superannuation. The High Court quashed the order of the corporation, deleting the name of the petitioner from the list of the casual labourers, and the ground that the stand taken by the corporation is arbitrary, unjust, and unfair. The petitioner was entitled to rupees 1,000 for 40 months. That is the period approximately calculated from the date from which he was removed from his job till the end of March 1997, and accordingly the corporation was directed to pay rupees 40,000 to the petitioner as back wages, and the petitioner was to be taken back in his job, meaning thereby that the HIV status on the petitioner is no ground for terminating his job. He may be employed in some other job in the corporation which he can execute. The Gujarat High Court, in exercise of the power under Article 226, has shouldered the doctrine of parens patria, and said doctrine is applied to cases of earthquake victims in Bipin Chandra J. Diwan versus State of Gujarat, AIR 2002, Gujarat 99. The concept in jurisprudence of doctrine of parens patria is that the state has the inherent power and authority to provide protection to the person and property of persons such as minor and incompetent persons, like those rendered helpless due to earthquake disaster. Parens patria has been literally explained to mean the father of the country and is used to designate the state, referring to its sovereign power of parens patria jurisdiction. The necessity to refer the parens patria jurisdiction was felt by the Gujarat High Court that on the morning of 26 January 2001, an earthquake of the magnitude more than 7 on a Richter scale shook whole Gujarat more devastatingly of the entire Kutch district, having thousands dead, injured, crippled, orphaned and homeless. The government was unprepared to meet the unforeseen calamity and still find it difficulty through its inadequate machinery to carry out the gigantic task of rescue, relief and rehabilitation of the quake victims. Allegations have been made that in spite of contributions and donations to earthquake victims from India and abroad, there is a failure and lapses on the part of the government to provide relief to the earthquake victims. The reaction of the High Court was that the paradox in a democratic society is that people expect too much from the elected government and its executive, and its distrust in it and its functionaries. The court felt that it was too early to attribute any failure to the government machinery, and it is for distrust in the capacity to meet the situation which has arisen out of disaster. The court held that the contributions and the donations for relief to quake victims may form part of the consolidated or contingent fund of India. For safe custody of such fund and maintenance of his account, receipt and expenditure, a periodical check by audit was made mandatory. It has also been pointed out that the participation and cooperation of a body like Ombudsman as for stupendous tasks like long-range management of relief and rehabilitation operations. Such mechanism was held necessary. After a long consideration and analysis of the magnitude of the problem, the High Court concluded the case by holding that the petitioners, with the help of the individuals and the service organization and also agencies and authorities to whom the court has issued directions, will work in a spirit of cooperation between them with one single aim, that is, providing relief, remedy and rehabilitation of earthquake within the quickest possible time. To conclude, it is important to note that the role of the High Courts in the protection of human rights to be noteworthy, as the powers of the Supreme Court to enforce human rights is limited to the enforcement of the fundamental rights. The scope is wider for the High Courts. The High Court can entertain the enforcement of not only fundamental rights, but also other legal or constitutional rights. The popularity of the powers of the High Court is prominent for other reasons, that the High Court is located within the state, closer to the inhabitants of the state, whereas the Supreme Court is located very far, having its concurrent powers to enforce the fundamental rights. People choose to go to High Courts to invoke the extraordinary power. Various aspects of the constitutional and legal rights are enforced, and High Courts play a very important role in upholding human rights with human rights within the territorial limits. It covers custodial deaths, parents' patria role, the role of an educator, and keeping vigil on various invasion of rights. The health, hygiene and sanitation is also looked into. Even medical negligence cases are entertained as a matter of enforcement of human rights. Thank you very much.